We're the team leaders and founders of Team Tammy. We're a residential sales team, listing focused Playa Vista, Westchester, Playa del Rey, and then our team also helps with purchases all over West LA and the South Bay. Tammy has been in real estate for over 17 years, and we established Team Tammy about 8 years ago. And over that time, we've helped a lot of clients with leases as well. And that part of our business has continued to grow over the years. Just over the past 4 years, we've helped our clients lease 125 units or their homes.
And over the years, many of our clients have asked if we could help manage their properties. And this was just not something that we did, but it led us to start Foster Property Management. And it took us a long time to really think through who Foster Property Management was and how we can best serve our clients. Foster is more of a boutique property management company, working with owners of 1 to a few properties in the markets that we know extremely well. Our mission is to provide excellent service by focusing on clear communication and caring for our clients' properties as if they are our own. Part of this mission includes staying up to date with the ever-changing rules and ordinances pertaining to landlord and tenant matters. This is why we are all here today, to hear from attorney Eillen Kendall, who is an expert in these matters. Please welcome Eillen Kendall with Kendall Law Firm.
Good evening, everybody. As you said, my name's Eillen Kendall. Just to give you a little background of me so you figure out why you could trust what I say is I've been practicing now 20 years. That's really hard for me to say. Just hit my 20-year anniversary. I have been in the real estate industry in law even before I went to law school. It just ended up, that's where I worked. And then out of law school, that's what happened. And so when I went out on my own 6 years ago, I went out on my own because I was tired of having to deal with somebody else managing my time, and I had a small kid and wanted to be able to have time. Lo and behold, my practice has grown from me in the last 6 years to a team of 6, and I still have no time for my kid. But I'm ever thankful. And as a part of that is landlord-tenant. People understand that. And so when I went to B&Is and started marketing myself, that was the thing I did. And my practice has grown. We represent, I don't even know how many property management companies anymore, and big ones. And we handle probably 50 to 60 evictions every month. And then we also have files called landlord risk management files. So if you have 1 or 2 properties and just want to have somebody on hand to ask questions and say, oh, can I do this or can I do that, we have something available. And so that's kind of why I became so versed in this, especially during COVID. I had a book about this thick because every single city had a different moratorium. Well, it's getting that way, and unfortunately we're in print for the newest updates, but I even created a book that put all the cities together so I would have it in one place. The problem is every time I go to print, a new city adds something. So it's only as good as the day I print it, but I put that in there. As you always should, if whatever I say today may not be what it is tomorrow. Right now, there is several bills getting pushed through legislation that are going to change some of these rules. Measure 8 in Pasadena, just kind of while it was already enacted, is just starting to go into play. And then, of course, at the end of COVID, the city of LA decided to change their rent stabilization ordinance. Now, there's 2 different things. And that's what I'm here to speak about today, is the city. Everybody uses rent control as a kind of term. That's not really what they are. It's just kind of a generic term. So what you have in LA City is you have the rent stabilization ordinance, which is back from the 1970s, and only have to deal with multifamilies. However, you have to keep in mind, if somebody takes a single family house and subdivides it even illegally and then rents the 2 out, you're now really subject to RSO, and you should be having those registered and doing that. The thing that happens when you don't follow these rules and you collect rent, when you want to evict them, they're going to turn around and sue you for all of the rent you illegally collected. because you're not allowed to collect rent if you don't have a certificate of occupancy, if you don't have it registered with the city, if you don't put the notice up. So there's really significant issues. But I always say it's not a problem until it's a problem. And that's when my clients realize that they're in trouble, is when they want to enforce their rights. So a lot of what I say today, well, yeah, the government's stepping in too much. It's nothing we can do about it. It's California. I'm going to talk a little bit about the rent stabilization ordinance is what is in LA City for the multifamilies. And what it does is it caps your rent at 5%. No, I'm sorry. Between 3 to 4%. There's a rent freeze now, and the city changes that every year. They set the amount you can raise the rent. There's fees that are involved, and if you pay for electricity and gas or something else, you can add another percentage to that, but you have to make sure you're following those rules. The other part of it is what the rest of the city now did is your just cause. So what that is in these properties, you cannot terminate a tenancy unless you have just cause. And there's two kinds of just cause. There's no fault and at fault. At fault, you can do those every day because those are non-payment of rent, not allowing you to enter, breaches of the lease. You have to be mindful, they have to be significant. I had somebody call in and like this. I'm like, no. Well, that's a pain in the butt, yeah, but you're still, a judge is not going to. And most of the time, if you ever have to really go all the way to trial, they're gonna ask for a jury because tenants got that right, I don't know how many years ago, and they like to extort landlords because that's their job. That's what they do. The attorneys ask for a jury trial in hopes that the landlord will just pay them some money just to get them out. And that's usually the result. And a lot of times a jury's not going to be sympathetic to a landlord if you're in the city of LA, because most of the people that you get on a jury panel are probably going to be tenants. So that just cause ordinance kind of came as a result of the eviction moratorium ending. I think the city felt that they needed to protect more tenants, and so it was passed and became effective on January 27th. On your chairs, there's two things. The first is a little pamphlet that is available on my website. I have them for most of the local cities. You can download and get them if you have property in different cities, because they're all very different. Some are similar enough, but there's some like Inglewood that is very cost prohibitive to try to terminate a tenancy. So those are available, and this is a summary. The other thing on your chair is if you have a rental property, this is the notice that the city put out that now must be given to all tenants. And weirdly enough, and I'm going to guess that a lot of you just have maybe one property that's, say, a condo or a townhouse. The thing that they said in the ordinance is it has to be posted on the property in a conspicuous place. Okay, well, in a multifamily, that's the laundry room or the mail room. If you have a single family home, where do you put that? Good question. I would say if you have a garage, you're going to put it in the garage. You're going to laminate it and put it in the garage. If they don't have a garage and they have like a laundry room, put it there. I'm really not sure when they enacted this how they thought that this was going to play out, because it's not like there's a common area in a single family. And when I talk about single family, it's not just a house. It's a condo. What really the legal term is separate and alienable among itself, meaning I can sell it separate of all the others. So in a condominium unit, I only own one, I just sell my one. That's what that means. The simple way is to say single family, because only one family typically lives in it. But it's, if you have a 2 on a lot, that's not a single family, and that's going to be a part of some of the other rules. So the just cause covers pretty much every single rental property. There's a very few small exceptions, and not like you guys would have them. Transient hotels, licensed care facilities, fraternities or sorority houses, owners with roommates. Those rules don't apply to those, and those exceptions are on the list. But what it did is it expanded your just cause to not just multifamily. It now applies to those single family homes. That affected a lot of my clients that are realtors. not even my clients, but my contacts that are realtors, because I get those calls all the time. I want to sell my condo. I want to sell my house. Can I evict them? That's not cause. Where before January 27th, I could say, yeah, you just give a 60-day notice. You can't do that anymore. And more cities are falling. There's only maybe 3 or 4 that are super old. Everything else is 2019 and above. So what can you evict for? As I said, tenant is at fault. That's the failure to pay rent, failure to cure a violation. Now, what that means is if they're violating the lease and what they call a curable thing, like they have a bunch of stuff in the common or like on the patio, and your HOA says you can't have those, and you're getting fined for that. Just because you're getting fined for it doesn't make it so that you can just terminate. You have to give them notice to cure that violation. So it's usually, and every city's a little different, and I'm not sure on this one, but typically it's a 3 or a 10-day notice to cure or quit. And you have to put in there what the lease provision is and how they violate it and what they need to do to fix it. After those 3 days expires, and it's 3 business days, so it's excluding holidays, Saturdays, and Sundays. Once that date expires, then you have to do what's called a 3-day notice to quit. And then you start the legal eviction process. If they're creating a nuisance or causing damage to the property, this is the one we saw the most during COVID, and what most of our evictions were in COVID. Well, people thought that you couldn't evict, and unfortunately, there's still ways that you could evict for non-payment of rent because the protections as they morphed, because I think it changed like 13 times. As it morphed, it got clearer and clearer that only certain classes, certain categories of people were protected. Like right now, it's only those that are 80% below the median income for the area. But the other thing is they made it a burden on the tenant. So if you had no reason to believe that they couldn't pay the rent, for instance, they're going on vacation and they got a new car, we proceeded and we actually won a jury trial for a Santa Monica, Venice city property for non-payment of rent because he couldn't prove that he had suffered a financial distress. So the same with nuisance was a very common one, and nuisances are the ones that I see are, if you have a condo in a, 2 or 3 story and your condo's in the top, we had to evict somebody because she was crazy and she was like, it was like throwing, when we had like 2 or 3 people, she would sweep trash into the balcony below and she would stomp and scream and yell and all of those things. So it's the legal definition, and most leases you have a covenant for quiet enjoyment. If a quiet enjoyment of your people in the surrounding, I think it's 500 feet, I can't remember exactly, but your surrounding neighbors, if they're bothered and they're making complaints, that's considered a nuisance. Now, depending on the type of nuisance depends on whether you can do a 3-day notice to cure or quit or a 3-day quit. Because if the things are so severe, like criminal activity, things like that can go straight usually to a quit because they're not curable. You know that they're dealing drugs because people are coming all night long. You can assume that they're not going to stop that. We usually do the cure or quit just to be on the safe side because we want to seem like we're reasonable. Using the rental unit for an illegal purpose. For instance, I have some people have come to me, I rented this house and she's using it as a restaurant. It's on Yelp. And then she tries to say, I'm not using it as a restaurant, but it's on Yelp. That's an illegal purpose. I mean, illegal in the sense that it's a lease violation, but also depending on the municipality, and I have to be very broad because I literally have to look up every city and every address that anybody calls me about because you can't assume. For instance, there's laws for unincorporated county and cities that are incorporated. Well, I live in Torrance. I deal with a lot in Torrance. My office is in Torrance. Somebody calls about Torrance, and I learned my lesson. You learn from your mistakes. Torrance is an incorporated city? No, you don't. You're fine. Oh no, there's this one little strip that's unincorporated. And so now we have a new resource to go to confirm. So just because you have a particular address, you always definitely want to double check what you're under. And there's resources for that. There's websites that you can type in the address. And that's how you determine whether your property's in the city. It's called zemis.org. And you type it in and it will tell you, it'll come up if it's in the city. And then if you go to housing, it will tell you what you're subject to. One of the other things is failure to renew a similar rental agreement. And it's a little more specific than that, is that if it was entered into by a certain date and expired by a certain date, if you give them a new lease and ask them to sign it, and it's similar and like no major jumps in rent and things like that, and they don't sign it, that can be cause. I've never prosecuted one of those, so I don't know what a judge would think, but I used to use this trick with city properties that my clients inherit and have no lease or have a really old lease from like the 90s or 70s, so that there's a clear lease in place. Reasonable access. If you have tenants, they're required to give you access. Now during COVID, there was a small period of time where you couldn't. That is gone. So if you need to make repairs, if you need to show it for if you're really thinking about selling it, whatever it is, you have, as long as it's a reasonable, you're not going in to harass them just to be in there. If you have a reason to be in there and they refuse to allow entry, that's a reason to terminate. It's a 3-day notice to cure or quit. And what I usually tell my clients is arrange for like the handyman. I need to have the handyman to come in and make these repairs. They've refused. Okay, so we're going to do a 3-day notice to cure or quit. And on that third day, that third business day, you're going to show up with that handyman. And if they refuse entry, they didn't cure the defect. And now we can do a 3-day notice to quit. And once you serve the quit, first of all, you don't collect rent, but there's no curing. You don't have to let them stay. You can go with the process. The other one is the person at the end of the lease term is a subtenant not approved by the landlord. This doesn't happen very often, but does happen. So if the person living there moved out and somebody else is living there and you don't know them, they didn't go through the process, that is grounds for termination. What I see more often is a caregiver or somebody that is a girlfriend of the tenant or an adult son that's moved back in to care for that parent. Once that person passes away, your tenant passes away, they really don't have a right to be there. And so those are the instances that we've had to. The other where we see it is in estates. It's interesting is you be creative, but you have heirs to an estate and the only asset is the estate. And I had one where the person that was in the property, while he was an heir to the estate, he was damaging the property because he was doing drugs and having people go through there and things were being stolen. But the house was the only asset and the trust provided for his care for his life. Well, the only way to fund that was to sell the house. So we had to terminate his tenancy. We offered to pay for him to move because the estate was going to do that anyway. So there's weird instances that you may come across in properties that you just want to talk to somebody because there are different rules and different ways that you can do that. Now, the biggest one now is because that would be the case in any city or county, even if you didn't have any protections. Those are pretty much normal. Like if there were no protections in place for tenants, those are always a reason because they're at fault. They're in breach of the lease. The tenant is not at fault. This is the big change. So now every single property in the county, you have to have one of the enumerated no fault reasons, and they're very limited. And you have to pay relocation. So an owner or immediate family member moves into the rental unit. If you have a multi-unit, it's a resident manager will move in the rental, but that's usually when you have a lot of units. Demolition, substantial remodel, or permanent removal from the rental market or conversion to non-residential. Now, The permanent removal is something that you have to go through a whole separate process with. It's called the Ellis Act, and there's declarations and things to fill out. The owner occupancy, also, you need to make sure that you're filling out the declarations and, things like that. And then substantial remodel, they're making more and more rules about that when you do the notice. It has to be something that is not safe to do while the tenant is in place and will take more than 30 days. So if it's something minor that can be done during business hours, it's not a substantial remodel. Putting in new cupboards and things like that are not. It's got to be something that is, usually the definition is structural, asbestos, plumbing, electrical. And what you have to do is, what I tell my clients to do is go talk to a contractor and get a bid and mention this to them, and then they'll put it in the bid for you. A government order to vacate. These are interesting. So for instance, I had a property manager client text me, I need to talk to you. 2 of our buildings caught on fire and burned down last night. I have to do something with all these tenants. What do I do with them? Because now it's red tagged. So that's a government saying, obviously, there's nothing left, that they can't be there anymore. Usually, I would guess most of you have, condos or homes in this nice, beautiful neighborhood, that these aren't going to be an issue. A lot of times I see these. My one client inherited a property from her mom, and there was a travel trailer in the back, and somebody was living in it. So the city gave a red tag and said that's not habitable, and so that's a government order, and so that's a valid reason to terminate. And then conversion to affordable housing and some other ones on the list I don't think are things that you would encounter, but those are the only reasons you can evict, nothing else. And with any of the not at fault, you have to pay relocation. Now, the one thing that the city did is gave you a break. If you are what they consider a mom and pop, and it's a single family, your relocation is a lot less than what it would be if you don't. Mom and pops are considered you own no more than 4 rental properties in your own single family home. So as long as this may be your only rental, or you only have 2 rentals, then you're probably going to fall into that category. And the range is from $8,850 to $22,950. But I just realized I wrote this a couple months ago. July 1st is the date that it changes. So this dollar amount, and I checked on it today, but I don't remember it. This dollar amount changed on July 1st. So you would want to double check. That lower number is if you're a mom and pop. That higher number is usually when you have what they call a qualified tenant. They're 65 and older, they have a disability, they have minor children, things like that. Those are the things that require. But you definitely, if you're going to try to terminate a tenancy for no fault, you want to check to see what the relocation is and if there's any changes. And it also sometimes depends, and they change it, and some cities require a sliding scale. If they've lived there 1 to 4 years, it's this amount. If it's this, and then if they're older, you have to add 1,000. That's Inglewood. So the other really important thing is that other paper that I gave you. If you have a lease that was began on or after January 27th and you weren't aware of this form until today, you're going to want to go give that form to your tenant. And how I would say is the best way to do it is like, if you're doing it yourself, you're going to write up some kind of addendum to the lease. This is the required notice, and have a place for you to sign and have a place for them to sign. But again, you might seek some assistance in doing that, but they have to be given. If you had a tenant in place prior to January 27th, when that tenancy renews, you have to give this notice. Now, a lot of people just let things go month to month. They don't require them to sign a new lease. They haven't really explained that. So what I'm going to say is at the end of their 1-year lease, you're going to want to give them this notice. Because if you don't do these things and you want to evict, they're going to put these as affirmative defenses. Obviously, these are brand new. We don't know the judge's temperament and they're going to take these, but these could be deemed fatal defects that get your case dismissed and you have to start over. So you want to do that. Evictions for non-payment of rent, just so that you know, for all rental properties, whether they're RSO or this just cause ordinance, effective as of March 27th, landlords may evict a tenant who falls behind in the rent. And again, I said, unless the tenant is 80% below the median income, and they have to prove that. But the newest thing that they added is now, and I think it's on that sheet on the back page, is this economic threshold fair market rent. So what this means is, unfortunately, if you have a rental that you've had rented for a long time and it's under market and you haven't raised the rent in a long time, which I see a lot of, you may be a while before you can terminate the tenancy, because now you can't do a 3-day notice to pay or quit until the dollar amount owed meets this minimum threshold. So if you have a 2-bedroom and your rent is only $1,000 a month, you're going to have to wait 3 months before you can terminate for non-payment of rent, because a 2-bedroom's minimum threshold, which is what they categorize as the fair market value, is $2,222. And so it takes a little while to get to that dollar amount. Something to keep in mind is if you have this and look it up when you're renting it out, at least then you know what the fair market value is and rent it for $1 more. I mean, it changes, but at least you're close if you're re-renting. Then the other biggest thing, and we have had property managers fail to do this. They've sent us a bunch of files. It was a new client. We trust that our property managers are doing all the things they're supposed to do, and then just send it when it's ready for filing. You have to give whatever notice to terminate, whether it's a 3-day notice to pay or quit, a 60-day, 30-day, whatever it is. You have to submit it to the city within 3 business days of it being served. I don't do it. My paralegal does, so I don't know, but I understand it's a portal or an email, and then you can have verification that you put it in. You don't do that, it's fatal. We had to dismiss like 15 cases because they realized they didn't do it after the fact. So again, these rules should be, while they seem terrible, they have to be followed because the ramifications are significant. One is that you can't enforce your right because you're going to be kicked out because you didn't follow the rules. And the other biggest one is, in most of these legislation and these rules, is if you are not following the rules, it's illegal to collect the rent. You can't legally collect rent. So I've had cases where, you're trying to evict me, you owe me $100,000 because you collected all this rent and this wasn't permitted, or this wasn't registered with the RSO. So you want to make sure that you're following these rules. Now, another thing that's in place, and this is definitely not for RSO properties because that's capped. So on a single family, you pretty much can raise your rent to whatever you want. With 10%, it's 30-day notice. With over 10%, I think now it's 90-day notice. There's no cap on a single family. Now, if you have 2 units, there is a cap under the state law. It's 5% plus CPI. But if you have one that the cap is there's no cap, if you raise the rent more than 10%, the tenant can come back to you and say, I can't afford that, I'm going to move out. And then on the back side, it tells you, you have to pay them this dollar amount for relocation. It's called economic displacement. So for instance, and it's not just like the fair market value. The assistance is, again, per bedroom size. You have to pay the fair market value. You have to pay a certain relocation amount. You have to pay moving costs of a certain amount. So for a 2-bedroom, where the economic threshold to terminate for non-payment rent was $22.22, now if they say, I can't pay this, you've raised my rent 15%, you now have to pay them $10,299. So the tip there is don't raise your rent more than 10%. people always call, can I? Yes, but I don't suggest it. And the reason why people do is, again, I get a lot of people that inherit property from their family, and it's been under market because my dad was so nice, or my grandpa just never wanted to raise the rent, and they're still paying $900 and it's worth $3,000. So can I raise the rent to get it to market? Certainly you can. But if you raise it that high, you're probably going to have problems. But now they have this rule in the city that they can say, I can't afford that. There is legislation. This is ever changing. There's legislation that's being pushed through. It's into the next phase. It's been like redlined 5 or 6 times. I haven't looked at it recently. The last one was like in the middle of June. That's going to change the state law. So the state law has 1482, and I'll just cover it really quickly, is if you have a multi-unit, so 2 units or more. So if you have a duplex and you're renting a duplex out, this is going to fall in there. There is an exception for owner occupancy as long as you were owner occupied when the lease went into play. So if you had a tenant in the back and the tenant in the front moved out and then you moved in, the exception doesn't count. But there are going to be changes. I don't know exactly what those changes look like. But my point is you always want to check. Talk to a professional. Get a property management company. Do something to make sure that you don't. Because what happens is people come to me after they tried to do it themselves. And then they have to start all over. And they wasted all that time because they didn't do it right. And even when I do consults, can I get these forms online? Well, yes. You can, but you have to be very careful, because if even the smallest thing, like a 3-day notice requires certain things, and one of those things is a phone number or a name of an actual person. Say you own your property as an LLC and you just put the LLC's name. Your notice is invalid and it will be thrown out. It doesn't have a phone number, it's invalid. If you don't have this or that, it's invalid. So while there's forms out there, don't trust everything that's on the internet. There's attorneys that have forms available. I would even check those to make sure they're the most current, because it changes so frequently that you don't know the last time they updated it, unless there's something like, I don't know if you saw me, I was kind of thumbing through a little booklet. I don't have it because I just went to print with the new laws. And I put a disclaimer in here that this is only as good as, I think I did this one in November 1st, 2022. The book adds like 5 more pages in it because of all the things that's happened since then. Like this handout that I gave you, the reason I did it in a handout is because it's not in the booklet yet. So I just created it. So that's kind of the rundown. So we can take questions. I'm going to grab my water though. Yes.
So, not trying to get a trick question, but I know that, now we wind up with the jury trials that they call for in doing eviction. A lot of our eviction records are sealed, right? So even though it's supposed to be sealed.
So if the sealing is only if you agree to that in a settlement. So one of the things that if you go to the court, almost every single judge has a nice speech that says, go out and settle this on your terms. And that's a throwaway term for us because it doesn't really matter. But once you go to a jury trial, I had opposing counsel try to argue that because it didn't go to trial fast enough, that it was sealed. I disagree with that.
Well, that was a part of it. My question was, though, is that a lot of people are agreeing to seal it so that they go away. And what that does is that affects the warrant, right, the next one. So my question is, I know we were limited on online searches, for example, the sex offender registry. How much now have they changed the rules where we are limited to the online searches, social media?
Well, I don't think there's any prohibition for you to do your own. I think what it is, and I know it just changed recently, and I don't know all of them off the top of my head, but there was new things where for credit and things like that of what you can ask for. There's even rules about what you can ask a prior landlord. It's kind of like, when somebody calls for employment, you can only say these things. That's really hard for landlords because they feel bad for the next person.
That's why I'm buying a lot of information that you can find. We've got, like on the west side, all over, we've got on the west side, big increase in foot traffic. And they're actually trying to rent the units. Now, they don't care about the rent. And so that's what the renting unit for, and you can find a lot of it online.
Yeah. Yeah, I mean, you know, anybody can search just general social media if it's out there. I use social media for that jury trial. I found him on Instagram and found where he was in Ireland in the Caribbean. So it's just a matter about, for us, it's admissibility at trial. But for making your decision, I think that I know property management companies have certain databases. Because I don't do those, I don't know what's in those databases and how easy they're accessible.
You mentioned the fair market value for two-bedroom for about $2,000. Okay, in a condominium, you're part of a homeowner association, so you have no control over how much the monthly homeowner association can go up. And because of inflation and the high electricity and gas costs, sometimes homeowner association increase year by year by over 15%. And you can't charge the tenant 15%. So you're always running behind. My question is, Lander raised fund of the Rent Stabilization Organization, which is the RSO.
Yes.
And on the certificate, it says the 3% limit increase does not apply to condominiums. It says that right on the certificate.
Interesting.
So you actually can raise the rent by more than 3 or 4%.
I didn't know about that exception. I'm usually, anything in the RSO has been subject to that. Now, there are condo conversions and some other instances, but I'm not aware of that exception.
Okay, if you
We learn
look
something
at-
new every time.
If you look at an average two-bedroom here in the area, the rent is like $5,000-6,000. So the fair market value of $2,000 does not balance the $5,000
So
what
what,
the
for,
landlord is charging the tenant.
so for purposes, yeah, so purposes of this law is not for those properties. This is more for properties that are low, because obviously the fair market value for a 4-bedroom based on, it's a HUD, I think. It's a website that gives the fair market value for the Los Angeles area. They say that in Los Angeles, the 4-bedroom is $3,170. If your rent is $5,000, you're not going to have to worry about when you can do a non-payment of rent. This is for a non-payment of rent. So what it means is, if you have somebody that's past due 1 month's rent, then you don't have to wait. But if your rent is only $2,500 for a 3-bedroom, you can't do a non-payment of rent that first month. You have to wait for the second month, because a 3-bedroom is $2,888.
Okay, but my question is, when the term of the lease expires and you're ready to increase the rent in a condominium because the homeowner association has increased the monthly payment for owners of the condominium collectively by maybe 10-12%, and they do that simply because they have no choice. Electricity, labor, inflation, everything costs so much.
Right.
That they can't keep up.
Okay, and so what's the question?
What is a landlord to do? Can I increase the rent?
So you, like I said, you can, but then this other new law goes into place. And what it does is, if you raise the rent more than 10%, the tenant can turn around and say, I can't pay that, and now you have to pay them relocation. If it's a 4-bedroom, you have to pay $14,000 in relocation.
Okay, and that's what I'm trying to avoid.
So then don't raise the rent more than 10%.
So it's, you're between the rock and the hard place.
Yes, absolutely. I didn't say these laws are fair. I didn't write them. I think they're terrible. Honestly, I don't have rental property in California anymore.
The people in local government don't have the faintest idea what they're talking about.
I'll tell you, today I got news alert that the county Board of Supervisors is pushing through a bill not to help landlords or not to help tenants pay the rent, but to pay attorneys to represent tenants in cases. That's how bad it is. I didn't say that. I don't like politics. I stay away from politics. But some of these things that they're pushing through are insane to me, and that's just probably because I'm in the industry. Because I see it, and I see what it does to my mom and pops. Some of these rules are going in place because you have big corporations that own some of those big corporate things, and they don't take care of it, and there's slumlords out there. But my poor mom and pops all during COVID were dying because they weren't getting rent, they couldn't sell it. All they wanted to do was get out from under this, and this doesn't help that.
Yeah, that was actually my question. On the right to counsel ordinance that passed a few days ago by other county supervisors, how is that going to affect everyone now that they did pass that?
So really that just makes my job harder in the sense that I would say that 50% of our cases, the tenants represent themselves. That's really great for landlords because we have tips and tricks that we can get these cases done without a trial. We serve something called request for admission, where we ask all of the questions that we would need to prove at trial because they don't know what they're doing, they don't answer them, and I go get them deemed admitted, and then I win. When you have an attorney, they put in all of the affirmative defenses, they ask for a jury trial, and then they sit there and extort the landlord for money because that's the only way they're going to get paid. This might be different in the sense that the county is paying them, but I think the same tactics. It's going to be the same attorneys. And, my senior associate knows them all, has their cell phones, and has good rapport with them, so she can usually try to settle them out. It's just going to mean that they're going to have more cases, which means more things are delayed because we have been set for a jury trial in a case that today was the third setting, but he's engaged in another trial, so it's been continued again. And so when these attorneys take on these cases, they get overloaded and they can't be in more than one place. So it's just going to slow it down. I'll be busy.
If a landlord wants to sell in the city of LA and the tenant isn't allowing access and you serve the notice, do you have to pay relocation fees or cash for keys or any of that?
No, so we'll talk about cash for keys real quick. That's at fault. If they are refusing to allow access, that's where you serve a 3-day notice to cure or quit. On that third day, you show up with your whatever it is to get access. And if they refuse access, you do a 3-day notice to quit, and then you start the eviction process. When they're at fault, there's no relocation because they're being bad. So think of it that way. If they have breached something where they're breaking the rules, you don't pay them. It's when they've done nothing wrong and you just want them out that you have to pay relocation.
Okay, and if they turn around and they start allowing showings, do you have to sell the property with the tenants? How do you get rid of the tenants?
Unfortunately, yes, unless you can negotiate a cash for keys.
Okay.
During COVID, cash for keys was king. Although I saw some that were getting offered $34,000 and help moving and they still rejected it. But because you have to have cause, selling your home isn't cause. So what I tell people is a part of the negotiation of the sale is if you can't get this tenant out, and I actually talked to somebody today that this happened in the transaction, is there's enough money for relocation and escrow. They bought it, and as a part of the negotiation, they can do, but they didn't talk to somebody first. It's RSO, and the lady is 65, so and lived there 10 years, they're protected. So they can't do owner occupancy. But say that there was, a young family, you could do an owner occupancy and just pay the relocation because they're not protected if you negotiate that cash for keys or the owner occupancy. And so it's, I've lost my train of thought. So the idea is you negotiate with whoever the buyer may be. Obviously, it doesn't work if the buyer needs to move right away or can't cover a carrying cost, but a buyer typically, in most instances, will want to move in. Yeah. So they can evict. They have the cause for owner occupancy eviction. You as a seller have no cause, so you can't. So I usually tell you, negotiate it as part of the deal. Know the relocation amounts and have it set in escrow. or you make a reduction in the purchase price to have to deal with the eviction. But there's ways around that. But once it's sold and they want to own or occupy, but please check, because like I said, there's instances where you can't do that. But that would be the way. But the seller can't. It's not cause to sell.
Great.
So I have a tenant who fell behind during COVID. Oh, thank you. Fell behind during COVID. He owes me like around $12,000. But starting this year, he's been paying every month. So what is my option? Should I?
Small claims. So if you look at the second page of the LAHD page, on the first part, it says COVID-19 rental date. It tells you when the repayment is. So if the rent was owed from March 1st, 2020 to September 30th, 2021, your tenant has to August 1st, 2023 to repay that. Now, in some instances, it could be grounds for an eviction, but if you were serving the, and this is so complicated, if you serve the 15-day notice during that time period and they paid 25% of the rent during that time period, you cannot evict. But you can go to small claims, and now small claims has opened up the limitations of what small claims is and has a special complaint for COVID-19 debt. So small claims is really, but if they owed rent from October 1st, 2021 to January 31st, 2023 and didn't pay it, they have until February 1st, 2024 to repay it. So you can't do anything until after that date. So it depends. Way back there.
Did I understand you on the renter protection notice to say that it's a good idea to update your lease, which I understand, but did you also say it should be posted somewhere where?
So this 2-page notice, I just did it to save paper. You should have it as 2 separate pages. It should be laminated and it should be posted somewhere, which I think is absolutely silly when you have, like I said, a condo. Where are you going to put that?
Right.
I don't know. Good question. I'm telling people just to find a place like next to the washer and dryer. I don't know.
But whether you post it or not, you should still send it to the tenant and just.
There is not if or not. If you're going to follow the rules and be compliant, you have to post this. It says you have to post this. Figure out somewhere to do, I don't know. But if you don't do that, I kid you not, the first thing they're going to do as a defense to an eviction is say they didn't post it. And I'm going to come back and go, hey, did you post that? Do you have a picture of the posting? Oh, no, I never posted that. You're not going to be able to evict.
And posted it in a common area is sufficient?
Well, so if it's a townhomes common area, no, because that's common area for the town, the whole community.
Right.
You have to post it in the common area of the in a conspicuous place on the premise. And that's why I said, if you have a single family house with a garage, nope, easy peasy, post it in the garage. If there's no garage, my next best bet is if they have even a nook of a washer dryer, go in and post it there. I don't know. Again, this is brand new. I don't know how the judge is going to go, but I'm going to tell you, you should follow the rules or it's going to bite you in the butt when you want to evict.
Is this for just LA City, just for LA County?
LA City only.
Oh, so will it be for LA County eventually?
I have no idea and I wouldn't be surprised.
Okay, that's all.
I can't tell you what's coming down the pipeline. It changes, like I said, this new 1482 for the state, it's been redlined 6 times. And things go through so many revisions, I can't tell you anything until I see it. So I always just say, take me for what it is today, might be different tomorrow. I saw another one. Hold on.
For single-family homes, if you have had originally you had a lease and you renewed it for 1 year, and after that it's been month to month, and the tenant has been there almost 5 years or a little bit over 5 years, how does that work, this new law, as far as,
It's all the same. So people like to think that there's no lease in place after the year. If you accept 1 month's rent after the lease term, it becomes month to month and it's still subject to all of the same rules. Now, under 1482, and it's very complicated. if their tenant has only lived there 11 months, or they've brought somebody in and both have only lived there, there are time frames that you can, but most of the time, they've already been there a year. And once you accept, now, here's the thing, is if you use, say, a lease, and it says that it terminates unless somebody gives notice that they want to stay, or a lease is renewed, that doesn't apply anymore. So typically, like if you see a realtor's form, it'll say, unless subject to local rules. So even if you had a lease that says it terminates, because typically, let's say we're in Orange County, on that last day, if you don't accept rent, I don't even have to give any notice. I can just file an eviction because it's expired and you're now a holdover. Not in LA.
And you said with the single-family homes, you still can go up to 10% rate increase
You
without
can increase
any
it 10%.
ramification.
I wouldn't suggest with the new laws that you go over 10%.
Right, of course, I understand that. And also, Playa del Rey is incorporated or non-incorporated.
So I can't tell you. I have like 3 sources that I go to on every single property, because even if it's, like I said, like Torrance, I just assumed Torrance, it's
Yeah,
this. But I have to literally, anytime I'm on the phone with anybody, give me the property address. And I put a search here, and I put a search here to verify. I can't tell you because I don't know.
What was
Honestly,
that-
there's just so many little pockets that I can't.
What was
say.
that website that you said you go on?
So the one for the city to determine whether it's not in the city is ZIMAS. I want to say it's .org.
It's on the bottom of this,
Oh, it is. It's zimas.lacity.org. Thank you very much. So what you do is, if you type in the address, and it tells you specifically how to type it in. You're not going to put north, west, south, or any of that. You put that in. If it pops up, you're in the city. And then there's a housing little section below. If you click on that, that will tell you whether it's subject to 1482 or RSO or Ellis Act. If you type it in, and I usually try like 3 or 4 ways, because I don't want to get in trouble that I missed it because I did it wrong or it's not doing it. If it does not pop up, then you're not within the city. And then you want to check for your area. For the unincorporated cities, there's like 79 of them, but I'm learning there's even more. So I think my PDF list that I got from the city or the county is not accurate. But we just learned of a new site, but I don't know what that is because I don't use it. But we have several different sources, because I have to check every single property. I can't be generic anymore.
And then my last question is that if you want to move in yourself,
So owner occupancy is allowed. You just
Okay.
have to pay relocation. You have to fill out a declaration that you're checking boxes that you are, and you're telling them what it is. And then you have to live there. I think they're changing it, but I think it's currently 3 years that you have to sign off that you're going to agree to live there for 3 years. It may be 2, but either way. And what happens is if you don't, because I just looked this up for a call I had, is if the tenant gives you, and it's a form, it's part of it, if when you terminate the tenancy for owner occupancy, and they give you written notice that they want to have a right of first refusal. Then if you move out within those 2 years, you have to offer it back to that tenant at the rent that it was. I didn't know that until today. So I don't know how new it is because I never saw that part of the form. Like it was not on the declarations before, and now it is. It's really, really hard. I know it's frustrating. I think that eventually everything's going to be this way. Like I said, just in the last couple years, or even the last year, Pomona, Bell Gardens, they're just all. Single family in Orange County is great because there's only there's only one city that has just cause. But the state, if you have multifamily, you're always going to be subject to this. So if you have 2 or more units, yep. Any other questions? Oh, yeah. So If you have no reason that's valid to terminate the tenancy, there's a procedure called cash for keys, where you're basically saying, hey, I'll pay you this if you move out by this. So in the Los Angeles City rent stabilized ordinance properties, there's a procedure to do that. There's a form that has to be filled out. It has to be provided to the tenant, basically telling them what their relocation is. I have negotiated them for less than that, but typically you're not going to usually do a cash for keys less than the amount that's required because they're getting notice that they're entitled to that. In the city properties, as of right now, you don't have to give that notice. So it's just a matter of whether or not they're good at Google or they're talking to somebody. You offer them, and I would say it sounds like for most of these properties, most of the ones that I deal with are so under market that it's a sticker shock for your tenant after 15 years to go try to find a new rental. So you have to think about that when you're doing these negotiations and consider that. And what I usually do is say give 50% at signing so they can go pay a security deposit somewhere, and then they get the other 50% when you get the keys. But what that means is you usually can't do it for $5,000 because that's not going to get them somewhere, especially if, what they're looking for is now, because they have to be able to pay for moving and things like that. So you just have to keep that in mind. So I usually say to be in the general ballpark of what the requirement is, but you don't have to give them notice. But it's a way to try to get them out. But I'll tell you, it's really hard. Like I said, I had one during COVID where they were trying to sell a house, and it was an investor, so he was up there in the money. I'm going to pay you $34,000 and pay for your moving expenses and this, this, and this. No, because they think it's their home. Not to be callous or whatever, but I was in front of a judge, I really like him, in Inglewood, and there was a lady there that was being evicted, and of course she was in tears, and my kid is on machines, and they're not doing this, and they're not doing that. I don't want to be evicted from my home. The judge said, ma'am, it's not your home. It's their home, and you're renting it from them. But when somebody lives there as long as they do, and I'm a renter, but I rent from my father-in-law, so I don't have to worry. But it's my home, and if they've lived there for a long time, it's really hard to get them out even with a cash for keys because they don't want to go. Okay. So really quick, I am on every social media platform. It's Kendall Law. I have a website. Like I said, these sheets, if you have property in other cities and you want to have information, there's other cities available on my website. You get on my mailing list. I send out, it's not always eviction, but a predominant amount of my information that goes out. Like the other day, I'm starting to do a Did You Know series. I'm not very good at it yet, but I was researching something for a client on trash and recyclables. And so I learned that there's laws like in Long Beach in certain areas that you have to have, if you have a 5 and more unit, you have to have seminars and tell them about organic waste recycling, and you have to do that. So I give tidbits like that, and if you follow me on any of the social media, I do FAQ Fridays that mostly have to do with rentals just because that's so big of my practice. But sometimes it's business stuff, sometimes it's other real estate stuff for real estate agents and stuff that I work with. But that's where you can get some information. You're very welcome.